Hi guys, welcome back. Today I want to review a video presentation that I found on TransCen Inc.'s YouTube channel. It's by Rachel Weisberg, an attorney at Equip for Equality. Now, if you don't know these two organizations, I'll leave links in the description so you can check them out, along with a link to the original presentation. I don't normally enjoy PowerPoint style presentations on YouTube, and this one is long, about 45 minutes, but it is packed with useful information about reasonable accommodation and how failure to accommodate claims are won. It includes a lot of basic information about the RA process, but what I want to focus on today are Weisberg's lessons learned from case law about how we and our employers should communicate during the interactive process. And the cases she shares in this presentation are great examples of how those communications break down. In court, the party who is responsible for the communications breakdown usually loses. Now, in this short video, I'm not going to have time to summarize everything Weisberg had to say in her presentation, but I do want to quickly walk you through an example. And at the end of this, I'm going to share some of Weisberg's tips on how to avoid these traps. So let's look at her first lesson. We don't have to use any specific words or procedure to trigger the interactive process. For example, in the case of Jones versus Clark County School District, Jones took a medical leave for job-related anxiety and depression. When he got back to work, he found he couldn't keep doing the same job because his symptoms were worse and there were side effects from his medications. He explained that to his boss and asked for a transfer as reasonable accommodation. His boss told him he had to submit his request to the ADA coordinator instead. So he did, and the coordinator misunderstood his request. Jones ended up being pressured into retirement instead of being reasonably accommodated. The court found in Jones's favor. They said that he met his obligations under the law when he told his supervisor that he had a disability and he needed a change at work because of it. They said that should have been enough for Jones's supervisor to initiate the interactive process. There's a similar outcome in the case of Duggar versus Stephen F. Austin State University. So that's an example lesson with the case law. And here's some more lessons that Weisberg covers in her presentation. Both sides have to participate in the interactive process in good faith. Just going through the motions isn't good enough, and both sides should be willing to discuss alternative accommodations. I'll include those in the associated case law in the description so you can check them out later. And finally, I want to share some of Weisberg's tips for workers who want to make their interactive process go as smoothly as possible. 1. Even though the law doesn't require us to follow a specific process to request RA, a lot of employers don't realize that. So they believe we have to do it their way or it's not a valid request. And if we don't do it their way, often they won't initiate the interactive process. If we want to get accommodated quickly and avoid a lawsuit, it's a good idea for us to follow their process as closely as we can. And if we encounter problems with their process, we should let our supervisor know as quickly as possible and ask for their help getting the interactive process back on track. 2. If our employer asks for something we don't think is reasonable, we should email them explaining why, and if we can, offer an alternative. 3. Both sides should be open to alternative accommodations. Our employers have to give us reasonable accommodations that are effective, if any exist. But they don't have to give us the exact accommodations we ask for. They're allowed to offer us alternatives. If they offer us an alternative that we know won't work for us, we should email our boss as soon as possible letting him know why it won't work and ask to discuss other options. And if they offer us an alternative we're not sure about, we should be open to trying it for a reasonable period of time with the understanding that we'll revisit later if it ends up not working. And of course, throughout the entire reasonable accommodations process, we should document all our communications with our employer and email so that in case communications do break down, we can show who's responsible. All of this is just a sample of what I got from this presentation. So if any of this was helpful to you, you might want to consider checking out the whole thing at TransCen Inc.'s YouTube channel. And I'll see you next time. Until then, take care and hang in. Fight smart,